Your series 2024 prelims. Well, as I told you in last class that we will first discuss about the current affairs of the political science, and first I want to discuss the medium of this class. As usual, it might be in English usually, and while I cannot express myself fully in English, I would try to explain you in Hindi. So today we are about to discuss 7 main important articles in this class. So let us start with our first one. It is about basic structure doctrine. So as usual, we will know why we have to discuss this. This is the most important event in our constitution. It changed the understanding of the constitution fully. So this is the historic judgment from the Supreme Court. We need to know about this. Without understanding the Keshwananda Bharati judgment, we are not able to understand the politics, the constitution. We can't understand the constitution. So let us start with what it is, little bit about its background and what changes it brought to our constitution, and little bit about the history before Keshwananda Bharati judgment. First, let's see what led to this judgment. What was the case actually? So here in Kerala, government brought the Land Reforms Act 1963. So in that they acquired money lands from the landholders. So a petition against Kerala government was challenging the compulsory acquisition of the land of the petitioner. So it was challenged in the Supreme Court. This 13 member bench sat for that, and it gave it a historic judgment. So let's see what were the points which were brought in, and what were the things which we have to understand and which changed the constitutional history of our constitution. Before understanding this, as we all know that before during this time, the land was one of the fundamental right to property was one of the fundamental rights of the constitution. So it was the fundamental right then. So उस वक्त क्या हुआ, जो केरला गवर्नमेंट ने अपना ये लैंड एक्विजिशन का लॉ लाया, तो उसमें उन्होंने बहुत सारा मतलब कि बहुत सारों की प्रॉपर्टी एक्वायर की, लैंड एज ए प्रॉपर्टी. So they challenged it in the SC in Supreme Court. So the point which we have to discuss here, what about our fundamental, can a Supreme Court, can Parliament amend the fundamental rights? This was the question which was to be answered here. So let us go to the brief history about the amending of the fundamental rights. If we will see from 1950 till 1965, there were many cases which were heard by Supreme Court, and there was a common judgment regarding that Parliament can amend any part, including the fundamental rights of the Constitution. For example, in A.K. Gopalan case 1950, Shankar Prasad case 1951, Sajjan Singh case 1965. So then after these cases, it was very much understood that fundamental rights can be amended, and there was not issue. But in 1965 only, Golaknath case, it is also one of the historic cases heard by the Supreme Court, and the historic judgment was given there, which was further changed in this Keshwananda Bharati judgment. In Golaknath case, what Supreme Court said that at 368 did not confer amending power to the Parliament. This was one of the judgments, and what they further added that final fundamental rights cannot be amended by the Parliament. So this created a huge fuss in the Constitution, and it was very much problematic whether that fundamental rights can be amended as a whole or not. So in 1972, this case came to the Supreme Court and they delivered the historic judgment in which they said that fundamental rights can be amended, but it preserved the basic structure of the Constitution. So it defined the basic structure, and in this judgment, we will further study, we'll further discuss how about what was the constitutional states of the preamble, whether it should be, whether it is the part of the, whether preamble is part of the Constitution or not. So these were the main important things which were discussed, which were discussed, which were given to us by the Supreme Court about our Constitution. So let us see what this slide is going to inform us. Kerala, it is all what we studied here. Let's move to the next slide and see what is there. Introduction, what it brought to us, it gave us the introduction of basic structure doctrine. This is that doctrine which cannot never be amended, and it is preserved by the by Supreme Court itself. Whether if Parliament has to amend any part of the Constitution, they have to check whether it is part of the basic doctrine, basic structure doctrine or not. If it is the part of the basic structure doctrine, then Parliament can never amend that. Further it corrected the judgment of the Golaknath case, in which Golaknath case, as I already said you, that was the historic judgment, but it was corrected further. In Golaknath case, what they said that fundamental rights cannot be amended by the Parliament. It corrected that. SC, it also upheld the 25th and 29th Amendment. So let us see 25th, what were 25th Amendment, what it said during that time. Curtailed the right to property with due compensation, proceedings of DPSPs over FRs, Directive Principles of State Policy over fundamental rights, took away scope of judicial review for 39B and 39C. So it upheld these amendments. Preamble is part of the Constitution and hence amendable. So it also further defined that preamble is also, as we know, in Virubai case, the preamble was declared that is not the part of the Constitution, but in 1973, this case, Keshwananda Bharti case, it defined that preamble is the very much part of the Constitution and it is amendable. So which part of the preamble is amendable, which does not, which is those things which are the basic structure, they can't be amended, but without the basic structure part of the preamble, that can be amended. So let's move to the next. So as from last 5 minutes we are discussing basic structure, let's see what is that. Basically, this is the certain fundamental feature of the Constitution that cannot be amended. No mention of there is no specific mention of the basic structure anywhere in the Constitution. So how we know the basic structure? It is what we say. We can say it is the guiding principle of the Constitution. Here we can see we can say it is one of the moralities of the Constitution. Gist of the Constitution around which our Constitution revolves. So these are few points which SC declared in different judgments, and these were added in basic structure. As a basic structure on whole, it is not mentioned anywhere in the Constitution. You have to remember that. मतलब कि basic structure जो doctrine है, एक Constitution में किसी जगह नहीं mention किया गया है. हमें ये they are given to us by the Supreme Court judgments. In different judgments हमें एक एक करके हमें मिला कि basic structure, what are these things, what are these points. So it came to us from the Constitution, from the Supreme Court judgments. So significance, what is the significance of the doctrine? Serves as in check on the powers of the Parliament. So what is the need to have the basic structure? So how does it help us to understand the Constitution? How does it help us to restrict the powers of the Parliament? So let us discuss a little bit about that. How is it used in our Constitution? It serves as a check on the powers of the Parliament. For example, if there were no basic structures, Parliament could have amended everything So it serves as a check what parliament is going to do. So basic structure will come as a shield and say to them that this part, this is the gist, this is the part which you cannot amend. So this is the a guiding principle which you have to, if you want to amend anything, this is the guiding principle, this is how you have to amend any part of the constitution. Ensure that the constitution remains a living document. So that it helps us in that preserves the constitution when it was framed. So that is response to the changing times while preserving its fundamental values and principles. It preserves the fundamental values and principles of the constitution. Lay down several principles that have become the bedrock of the constitution. It laid down this, as we know, which became the bedrock of the constitution. It laid down those principles, for example, sovereignty, socialism, etc. A federal structure is not undermined. So in this also, what we can understand that the federal structure of our constitution is not undermined. While if the, parliament goes for any amendment, so they would understand we, how we have to amend that, which are the how we have to amend it, and what we have to take in consideration while amending any part of the constitution. This is how it helps us to understand how it helps the parliament, how it helps us preserving the constitution in its actual form or preserving it as a living document. I hope I'm able to convey it properly. So what scope of basic structure? It leads to judicial activism. It conflicts with parliamentary sovereignty and difficulty in amending the constitution. These are some which we can say draw, as I mentioned in the previous class. Everything which is in this world does have two sides. They have the pros also, which may be leaping, which may be many pros, many good qualities. We can say, if we will define it in a layman's language, we can say they might have many good qualities, many progressive qualities, but at the same time they have some drawbacks also. So let us see what it leads. It leads to the judicial activism, where judiciary goes out of its reach and gets involved in different in executive actions or something like that. It conflict with the parliamentary sovereignty. It can, as we know, our parliament is sovereign but not supreme. So this is the basic principle of our parliament. It is sovereign but it's not supreme. Difficult in amending the constitution. If we have to amend the constitution, it makes it very much difficult. So as we know, our constitution is a living document, so it needs to be evolved by the time. What basic structure does, it hinders that process. It makes it difficult to amend any part of the constitution. At the same time, it is the pro of this, and at the same time it is one of the drawback of having the basic structure. So let us see some principles that are presently part of the basic structure. It is the sovereignty of India, essential features of individual freedom secured to the citizens, mandate to build a welfare state, supremacy of the constitution, republican and democratic form of government, secular and federal characteristic of the constitution, separation of power between the legislative, executive and the judiciary, unity and integrity of the nation, power of judicial review, harmony and balance between fundamental rights and directive principles of state DPSPs. So these were few basic structures which were given to us by judicial judgments. Now let's see what is the way ahead. We should have a clear what is the way forward, how we will deal with this. this basic structure of how we should let it govern us. It should have a clear definition. It should be clearly defined what constitutes the basic structure. So by having a clear definition of that, we will it will make understanding, it will make amending of the constitution easy for us. It will make evolving of the constitution very easy. If it is defined, it is it's one of the also limiting judicial activism and public awareness and participation. These are few important way forward which we should have in this. Now let's move to our second article. It is democratic decentralization. Let's see. Till now, let's recap our first article. It was about the basic structural doctrine. It dealt with the Keshwananda Bharti case, how it corrected the Golaknath case, in which it was said that fundamental rights cannot be amended. But in Keshwananda Bharti case, 13 member judges, they said that a constitution with fundamental rights is very much amendable, but leaving the basic structure doctrine, this is that part which cannot be amended by the constitution. So further basic structures are given to us by judicial remarks, and they are being added. Similarly, in Keshwananda Bharti case, one more thing was added, which is one of the most thing, that is the value of the preamble in our constitution, whether that is to be added in the constitution or not. And they said that preamble is very much part of the constitution, and that is also amendable, except those which are the basic structure doctrines. Now let's move to our second topic here. It is democratic decentralization. Let's see, as usual, we see why it was in news. It is in 2023. We have the 30th anniversary of 73rd and 74th Amendment to the Indian Constitution. It led to the establishment of local self-governments in rural and urban areas. For example, Panchayati Raj institutes and urban local governments. Ministry of Panchayat Raj, in collaboration with Government of Madhya Pradesh, PM inaugurated integral e-Gram Swaraj and GEM model. PM handed over Swamitya Surya, a survey of villages and mapping with the improvised technology in village areas. Swamitya property cards. So these were few tidbits which we have to see why it was in news. We have to Ministry of Panchayat Raj, in collaboration with the government of Madhya Pradesh. Madhya Pradesh is the only state which had 3 tier. It was the first state which had 3 tier. 3 tiers, which had 3 tiers. These self-governments, local self-governments. Now let us discuss a little bit about the 73rd and 74th Amendment Act. 73rd Amendment Act 1992. Panchayati Raj institution was constitutionalized through the Act. This Act has added a new Part 9 to the Constitution of the India and consists of provisions from Article 243 to 243O. In addition, the Act has also added a new 11th schedule to the Constitution that contains 29 functional items of the panchayats. What are the main points in it? Panchayati Raj institution was constitutionalized. It added Part 9, and it consists of provisions from Article 243 to 243O. And in addition, the Act has also added a new 11th schedule to the Constitution. 74th Constitutional Amendment Act 1992 for urban local governments were constitutionalized. It added Part 9A, and consists of provisions from Article 243p to 243zg. It also added the 12th schedule to the constitution that contains 18 functional items of the municipalities. I hope you would remember that. If you have pen in your hand, you will note these things on the paper. Now let us see what is democratic decentralization. As we know, it refers to the devolution of power, resources, decision making authority for the central government to the local government. It is the vertical distribution of the power from central government to the local government. See, now the 73rd and the 74th Constitutional Amendment of 9 that came into force in 1993, and they are the landmark legislation that introduced democratic decentralization in India, as I already explained it in the previous slide. So let's see what is the significant achievements of democratic decentralization. What are the significant achievements? First, empowerment of women and marginalized communities. The, it empowered in the proportion of elected women representation has also increased since these amendments. 49% of the elected local representatives, which are 1.4 million, are women, and over 4 lakh members belong to the scheduled castes and scheduled tribes. So it empowered the women and the marginalized communities, and it led to the healthy competition among states also. Since everything has some challenges, so let us see what are the challenges to democratic decentralization. What are the challenges to these panchayati raj institutions and urban local bodies? First, the most important challenge to them is the limited power and resources. They lack control over key areas like education, health, and policing. So they rely on central and state government grants, constraining their capacity to execute independent development plans. They lack huge power. They lack control over education. They lack control over health. They lack control over policing. They have very less limited powers given to them. The second challenge to them is economic inequalities. Some states and districts have better resources and infrastructure than others, leading to uneven development. There is very much uneven development, as we will see some states like, for example, we will see Maharashtra, we will see Tamil Nadu, etc., and we will see Mizoram, we will see UTs like when Jammu and Kashmir was the state. If we will see the difference in their in economics in economies of these states, we will see huge economic inequalities in states itself. Some had progressed very well, and some, for example, Kerala, they had progressed very well, and at the same time some states like Jharkhand, we will see they did not progress that well. So this is one of the challenge to the democratic decentralization. The third is bureaucratic hurdles. This, you know, it is very important to have the best bureaucracy. If any country which is achieving heights in present time, they had the best bureaucracy. Bureaucracy is the spine of the country. The country having the best bureaucracy, having the efficient bureaucracy, leads to the development of that country. So if any hurdle in the bureaucracy, it leads to the disastrous problems. So is the case with the self governments. But we have huge bureaucratic hurdles. For example, if we can explain it further, panchayat raj institutions and urban local bodies, they face huge bureaucratic hurdles in executing their plans and projects, which include delays in approvals, inefficient implementation, and the corruption, which destroys any country, any province to very badly. मतलब कि ये बहुत गंदे से किसी भी चीज़ को जहाँ पे भी करप्शन है वो उस चीज़ को बहुत गंदे से डिस्ट्रॉय करती है. So this is one of the drawback, one of the challenge of self governments. And the other challenge is the creation of parallel bodies. As what are the many states have created parallel bodies to take over the functions assigned for panchayats. For example, the Haryana government created a rural development agency under the chairmanship of the chief minister to oversee the works of local bodies. So this would definitely create a problem if these parallel bodies are created. And next challenge is social inequalities. As usually when we talk about the Panchayat Raj institutions, they have to deal with the rural areas. When, as we know, our rural areas still in this century during this period, there are lots of inequalities. There are lots of concerns still going in our society. So that is one of the challenge to the development of our self-government. For example, women and marginalized communities often face discrimination in local decision-making process, which limits their participation and influence. And one more challenge to it is lack of accountability. There is often a lack of accountability and transparency in a local decision-making process, which can lead to corruption and misuse of resources, and also weak capacity building. Now, these are few challenges which were which are hammering the development of democratic decentralization. For if you will write, for example, if in mains these questions are asked, you have to write it in this way. First, we have to define it. Then we have to talk about its pros. Similarly, what are the challenges? What is the way forward? What government has done to improve it? We have to discuss it like that. So we have to divide our question in these parts. In this way, we can get good marks in our mains exams. I hope you are able to understand this, and I hope this will help you uh, in cracking your exam. And definitely these topics which I upload here, you know these questions would definitely come from these topics. And one more thing I want to say here: if anybody who will listen to this video and he has not done his preparation that well, my advice to him is at least to watch these 10 to watch these current affairs videos, which I will for every subject I will have 10 to 12 classes. Watch them once, twice. Try to remember only these things. This may help. I won't say this will definitely help, but this may help you in your prelims exam, because mostly the questions which will be asked in our exam in our prelims exam, they revolve around these topics. And if you know the gist of these topics, if we know the conceptual, if we have the conceptual clarity, it gets very easy for us to mark the right options. So let's see what are the steps taken by the government. For example, first, Rashtriya Gram Swaraj Abhiyan. It was for developing and strengthening the capacities of Panchayat Raj institutions to become more responsive towards local development needs. Second, e-Gram Swaraj. It is a user-friendly web-based portal, unifies the planning, accounting, and monitoring functions of Gram Panchayats. Then we have People's Plan campaign, Sabki Yojana Sabka Vikas, to draw up Gram Panchayat development plans in the country and place them on website where anyone can see the status of various government flagship schemes. It is actually about people should know what are the schemes, what are how we can get benefit from them. Then we have backward regions grants fund. Under this, united funds are given for meeting critical gaps in local infrastructure and other development requirements in some identified backward districts. Then we have National Institute of Rural Development and Panchayat Raj, which is an autonomous organization under the Union Ministry of Rural Development. So about this you should write it if you are hearing this lecture. If anybody is hearing, which I hardly guess anybody would see this video, if you are hearing it, they definitely write this point about National Institute of Rural Development and Panchayat Raj. You should know that it is an autonomous organization. It is under Ministry of Rural Development. It is for capacity building of rural development functionaries. It has elected representatives of PRIs, bankers, NGOs, and other stakeholders. Then we have National Panchayat Awards. Under this, best performing panchayats are selected based on various criteria and indicators. Then we have Samitva scheme. What is it? It aims to provide the record of rights to village household owners. It issues a property cards to their property owners. This empowers PRIs, Panchayat Raj institutions with better data on land ownership. So what is it? It aims to provide the record of rights to village household owners. Record of rights, it provides those and issues property cards to the property owners, and it empowers Panchayat Raj institutions with better data on land ownership. Now let us see what is the way forward for this. First is we have to strengthening of financial devolution. What this would do, this can be, how can we do this? This can be done through higher allocation of funds from the finance commissions and by exploring innovation sources of financing such as municipal bonds. Then second, what we have to do, what should be done, it is capacity building and training, then empowering Panchayat Raj through legislation, then leveraging technologies. These are few things which should be done. And one more important thing is it is about the strengthening the role of the woman. So this was about democratic decentralization, our second article of today's class. Now I will take 5 minutes break, then I will come back. Yeah. Now our third article is cooperative federalism. In democratic decentralization, what we studied was about the horizontal relation from central government to the governing bodies, local self-governing bodies. But here about cooperative federalism, it is about horizontal relation between union and the state, and it shows that neither is above anybody. Both are at the same level. It shows it, but in reality, we know that we have the strong center. It shows what I mean. There we have the provisions where there is a cooperative federalism, but where it is needed, where we need to have the strong center, there we have a strong center, where center can overcome state where it is necessary. Let us discuss about it. What it in Indian Constitution has incorporated instruments to ensure cooperation between the center and state. Let's say about study. Now let's discuss it in a better way. Cooperative federalism, it is the horizontal relationship between union and states, which I already mentioned, in envisages that national and state agencies undertake government functions jointly rather than exclusively. They jointly function these take these government functions jointly rather than exclusively. Indian Constitution has incorporated instruments to ensure cooperation between the center and the state. Similarly, we have Niti Aayog, which acts as a platform to promote cooperative federalism in India. So let us see our next slide. What is the need of the cooperative federalism? It addresses the regional disparities. To achieve inclusive and balanced development, states must collaborate with the central government to bridge socio-economic and infrastructural gaps. To balance these gaps, to bridge socio-economic and infrastructural gaps, states must collaborate with the central government. Then the second need for is effective implementation of policies. This leads us to the effective implementation of policies. For example, effective implementation of central government policies requires crucial cooperation between center and the state governments, as many policies are implemented by the latter. As state center is the they frame the policies, they fund the policies. At the end, it is to be implemented by the state and and the local government. So to achieve this harmony between the center and state, we need to have a state federalism. Then third is sharing of resources. Cooperative federalism it facilitates fair and equitable sharing of resources. It ensures that all states have access to resources for development. Then we have it strengthens our democracy. It helps in strengthening the democracy. It promotes decentralization of power, giving more autonomy to the states. This helps to ensure that the diverse needs and aspirations of the people are taken into account in the decision making process. And collaboration on emerging issues. Cooperative federalism ensures that issues such as national security, disaster management, and environment protections are tackled in a coordinated manner, with all levels of government working together towards a common goal. So these are few needs for the cooperative federalism in India. Now let's move to the constitutional provisions to promote cooperative federalism. How constitution promotes it? What are the provisions in the constitution? Let's discuss about that. First, the most important is the seventh schedule, which we discussed in our last class, which demarcates central, state, and concurrent districts based on the principles of subsidiarity. Then we have all India services under Article 312. Then we have integrated judicial system to enforce both states as well as central laws. Then we have interstate council under Article 263 of the Constitution, which discuss and investigates the subjects of common interest between the center and the state. Then we have full faith and credit clause under Article 261, which provides the full faith and credit shall be given throughout the territory of India to all the public acts, records, and judicial proceedings of the Union and every state. Then we have zonal councils established as statutory bodies under the State Organization Act of 1956 to ensure coordination. Then we have Finance Commission under Article 280 for which recommends the distribution of financial resources between Union and states. Then we have GST Council under Article 279A, which is responsible for deciding the rates of the GST and the modalities of its implementation. Now let us see the challenges which are to the cooperative federalism. First and the most important is over centralization of power. The center enjoys more power than states on certain matters and imposes rules and regulations which many states find discriminatory towards them. Then second is political difference. For example, if center is ruled by some party and state is there, the majority is of different and government is of different party, then we get this political differences there, which creates a challenge for cooperative federalism. We have interstate disputes. The central government has often been called upon to mediate states between states over resources such as water and land, and has been criticized for taking sides Then we have diversity. India's diversity demands, as we know, our diversity is very huge. We have in different regions there are different tribes, different kinds of people. They have different approaches. They have different needs. So it is a big challenge. Then we have interference in state matters. This has led to a lack of autonomy for states. These are few challenges to the cooperative federalism. Now let's move, as usual, what is the way forward? Empowering local bodies, which we discussed earlier. Empowering local bodies such as Panchayati Raj institutions and urban local bodies to take up development activities and to enable them to play a more significant role in development process. Then we have financial devolution, increasing the share of the states in central taxes to increase the financial resources of states and to promote fiscal federalism. Then we have resolving central state disputes, which we have to do, promoting para diplomacy, and then inclusive decision making. These are few way aheads which are necessary for the cooperative federalism. I hope this would be enough for you to understand it and go. What I want you to do, please have your notebook and pen in your hand, write these points and think over them. Do little research over them, and you will find more interesting and more material regarding these topics. And I hope this much had improved your knowledge about these topics. Now let's move to our fourth article, which is which was in the news those times. It is which is usually in the news. It is interstate border dispute. Usually, why it is in news? Assam and Arunachal Pradesh signed a memorandum of understanding to end a decades-long interstate border disputes. We have we When we see our country, we see our how borders of the states are drawn, or borders drawn with the other countries. As we know, we are under British rule. The colonial legacy it is prevailing here, and that led to many disputes between states, between our neighbors. Also, we have disputes in Haryana, Punjab. We have disputes between Himachal Pradesh and Bangla and Ladakh. We have disputes between Haryana and Himachal Pradesh. Disputes between Gujarat, Rajasthan, Odisha, West Bengal, Maharashtra, Karnataka, Kerala. So there are disputes between the states regarding the borders. Same was the case with Assam and Arunachal Pradesh, but they signed the memorandum of understanding to end a decades-long interstate border dispute. So, what was this dispute was over 123 villages that stretches across 12 districts of Arunachal Pradesh and 8 districts of Assam. We don't need to know the name of the villages. UPSC won't go that far. It won't make it such difficult for the aspirants. You know the main for UPSC does not. We should know that it does not check our knowledge. It checks our capabilities. It checks how our smartness in answering the questions. It does not check our knowledge. If it would come to check our knowledge, then trust me, nobody can qualify the prelims exam only, because how much they can let us imagine our syllabus, the circle of our syllabus, and how much we had studied and how much has trained in our mind. If they would start checking the knowledge of this, only few will get selected, and I don't think it would get very difficult. So my point is, UPSC does not. They don't check our knowledge. They only checks our capabilities, our smartness. So let's come back to the topic. And dispute was over 123 villages that stretched over 12 districts of Arunachal Pradesh and 8 of Assam. State governments agreed that no new these two governments agreed that no new claim or village will be added in future beyond these 123 villages. As per memorandum of understanding signed, 34 of these villages had been resolved. The dispute over 37 villages had been resolved through the Namsal Declaration of July 2022. The, the exercise resolved the dispute had started with the formation of 12 regional communities in the south from both states. The suggestion by the exercise to resolve the dispute had started with the formation of 12 regional communities in 2022 from both states. The suggestions made by these communities have been accepted by the two states. These 12 regional communities were created in 2022 and their suggestions had been accepted by both the states. And one more thing, of 71 villages, an understanding has been reached where Arunachal Pradesh cedes one village to Assam while receiving 60 villages from Assam. 10 villages remain in Assam itself. They give one village and receive 60 villages, and the remaining 10 villages they will remain with Assam. Now let us see what were the causes of interstate border dispute. As I mentioned, it is the colonial legacy. Britishers they prioritized easy governance, leading to administrative unification and not cultural or linguistic unification. This caused a mismatch between people's personal identities and the territories they inhabited. Then we have varied geographical features, complex, for example, complex terrains across the borders in form of rivers, hills, forests. It make it difficult to clearly mark physical boundaries. Then we have inadequacy of mechanism to solve border disputes. We have political differences. We have non-binding nature of committees formed. We have lack of political will to resolve these issues. Now, what should be the road ahead? There are few points which I want to mention here. There we should have an adopting a give and take approach. Right approach towards such dispute is not seizing it as a zero sum game. It must be a win-win situation for all parties. We should understanding core issues. Policymakers must understand the disputes on issues. Then another, raising awareness among people, inclusion of all stakeholders, framing proper rehabilitation policy. People's interests must remain paramount while resolving these issues. Now let's move to our fifth article. It is about Aadhaar. This has been in news since 5 6 years now, and let us discuss what is in it and what is the information which we should know for our exams. First, we should know why it was in the news. For Ministry of Electronics and Information Technology has proposed rules to enable Aadhaar authentication by entities other than government ministries and departments for better delivery of services to citizens. So purpose for Aadhaar authentication, what is the purpose for that? It is promoting ease of living of residents and enabling better access to service for them. It is use of digital platform to ensure good governance. It helps in enablement of innovation and the spread of knowledge. It leads to prevention of dissipation of social welfare benefits. So it has a huge purpose, which we can see it here. Now let us see what are the issues with it. We have faulty database. We have concerns about residence status, which we know. We have incidents of authentication errors, which is often seen. We have system vulnerabilities, we have data leaks and privacy concerns, and Bal Aadhaar. What is the issue with Bal Aadhaar? Let us discuss it. The issue of Aadhaar numbers being issued to minor child below the age of 5, they are given the Bal Aadhaar. Based on the biometrics of their parents goes against the basic tenet of the Aadhaar Act. CAG report highlighted that. What does it highlighted? Unique Identification Authority of India has incurred avoidable expenditure of 310 crore on issue of Bal Aadhaars till 31st March 2019. Oh my god. And one of the issue with it is also updating biometrics. It is very difficult or not stable over the lifespan. Biometrics, they are not stable over the lifespan of an individual, so they are asked to update, re-enroll their biometrics. It gets very difficult. It is one of the issues. So let's see what are the initiatives taken to strengthen the Aadhaar system. Roadmap drawn for Aadhaar 2.0. Roadmap covers areas like continued focus on resident centricity, enhancing the use of Aadhaar, further strengthening the people's trust on Aadhaar. Then second, biometrics based deduplication. What is it? Biometric service providers presently operational use facial image as additional biometric attribute for deduplication along with 10 fingerprints and 2 irises. Facial images are also added in it. Biometric fraud detection can be currently detect mixed biometrics, wrong fingers, non-human fingers, gummy fingers, inverted iris images, and closed eyes during enrollment. Inspection of operators. Uh, Unique Identification Authority of India regularly carries out inspection to find out deviant behavior among operators. So these are few initiatives taken by the other by Unique Identification Authority of India. Now let us see what is little bit. Let us discuss about Unique Identification Authority of India. It is a statutory authority established under the provisions of Aadhaar Act 2016. It was established under the Ministry of Electronics and Information Technology. Earlier, it was functioning as an attached office of the Planning Commission, now Niti Aayog. Regional office. It has 8 regional offices, including data center and tech centers in different parts of the country. It has been created to issue unique identification numbers named as Aadhaar to all residents of India under Aadhaar Act 2016. UIDAI is responsible for Aadhaar enrollment and authentication, including operation and management of all stages of Aadhaar life cycle. Developing the policy, procedure, and system for issuing Aadhaar numbers to individuals, and etc. Now, what is the road ahead? Authenticate the residence status, strengthening grievance system, strengthening digital framework. These are few things which we have to deal with. And comprehensive data protection legislation. Now, moving to the next article, it is about land record modernization. So let us see why it is in news. 28 states UTs have adopted national generic document registration system for land records, and 26 states UTs have adopted unique land parcel identification number or BU Aadhaar. These here we have discussed about the land records modernization. In it, 28 states have adopted national generic document registration system and GDRDs, and 26 states UTs have adopted unique land parcel identification number. When I was writing this that time, I was very much confused about why 28 states and 26 states. I was getting very much confused. We have only 28 states. What is, how it is, how few are taking that and how remaining are taking that? But it is not the case. Like, it is not such thing. So 28 states. It involves the states which had also taken these. These, what are they? Unique land parcel, ULPIN, and 26 states. In them, there are those states also which had taken those NGTRDs. So it is the in combination of how 28 states, how many had taken both, how many had taken only one among them. I got confused by that, so I thought I would share this with you. Then we have National Generic Document Registration System. What I have wrote it there. System. I would correct it later. It is a common. Let's discuss about it. It is a common, generic, and configurable application developed for document registration departments across the country. It is initiated by the Department of Land Resources, Ministry of Rural Development. It is state specific for the citizen services, offering a complete user interface for property and document registration. The application enables citizens to proceed with land buying online. Its objective is enabling the idea of one nation, one software. It empowers citizen empowerment by enabling property valuation, including auto calculation of duty and online document submission. Single platform for all stakeholders in the registration process. So we should know about this. Who initiates it? Department of Land Resource, Ministry of Rural Development. This might be asked in prelims about National Generic Document Registration System. Who initiates it? Under which ministry it comes? So we should know about that. Objectives, as already said, enables the idea of one nation, one software, empowers the citizens, and acts as a single platform for all stakeholders in the registration process. Now, let us discuss about unique land parcel identification number, or BU-Aadhaar. It is a part of Digital India Land Records Modernization Program and is a 14-digit identification number. Identification is based on longitude and latitude coordinates. I like it. It provides single window service to citizens, standardization across states, easy sharing of land records, protects government land, and ensures transparency. What is the need for the land record modernization? So, first one is move towards conclusive land titling. The Land Records Modernization Program aims at adopting the system of conclusive title instead of present presumptive titles. In India, currently the ownership of a property is provided through presumptive land titles, record of rights. That is a chain of documents that provide evidence of the transfer of title from person to person over the years, all the way to the current owner. Also, if we need to know that according to Registration Act 1908, presumptive titling implies that state does not give a guarantee for such titles. So this is the need, most important need for land modernization to move towards conclusive land titling. And second is land disputes. To resolve those disputes, it is important. Then standardization of land records. The system of land records management varies from state to state. The standard templates throughout the country are needed for registration and record of rights. Then difficulties in the present system. The manual system of record keeping has become cumbersome, opaque, susceptible to manipulation, and hard to administer by the administration. Other advantages of land record modernization are reduced process and time, authentic automatic updation, single window delivery of citizen service, e-linkages to credit facilities. So This was about land modernization. Now coming to our last article of the day, it is about regulation of online gaming. As in last class we discussed about fake news. Similarly, the Ministry of Electronics and Information Technology has amended the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules IT Rules 2021. Now, let's see what is more in the news. What is the aim of these amendments? It is to enforce greater due diligence by online gaming and social media intermediaries in respect of online games and fake or false misleading information related to government business. The rules and amendments to IT Rules 2021 have been brought out under Section 87 of the Information Technology Act 2000. So the aim of these amendments is to enforce greater due diligence by online gaming and social media intermediaries. The rule and amendment is to IT Rules 2021, which have been brought out under Section 87 of the Information Technology Act 2000. IT Rule 2021 were brought out for regulatory social media intermediaries, for example, Facebook, Instagram, like that. Key features. It clearly defines what online games are and online gaming intermediaries. It defines the role of intermediaries to make a responsible effort to not host, publish, or share any online game that can cause the user harm or that has not been verified as a permissible online game by an online gaming self-regulatory bodies (SRBs) designed by the central government. Additional obligation on OGI. What is the amendment rules cast additional obligations on these online gaming intermediaries in relation to online gaming involving real money. These include the display of mark of verification, informing their users of the policy, obtaining the KYC details, not giving credit or enabling financing by third parties to the users. And multiple SRBs, the Ministry of Electronics and Information Technology may notify multiple SRBs, authority of SRBs. For instance, the SRBs may categorize any game as a permissible game if it is satisfied that the online game does not involve wagering on any outcome. The online game intermediary and the game comply with the rules and the requirements under law for being competent to enter into a current contract currently at 18 years. And what we have in this, and the OGI online gaming mediatories and the game complies with the framework made by the SRB regarding safeguards. Then we have prohibitions. Online games that involve any kind of gambling will be prohibited. Now, everything we know about these, we have to see the concern with the regulation of online gaming activities. For example, game of skill versus game of chance. Game of skill, in it we can example Dream 11 fantasy game, which is a game of skill, and the Indian law allows game of skill while prohibiting game of chances. However, there is no prescribed definition of either of them. There is no prescribed definition. Obstacle to foreign investment. This is one of the challenge. SRB discretion and different state laws. Gambling and betting is a state subject as per the Constitution of India. So, as we discussed in the 7th schedule in last lecture about union list, state list, so gambling comes under the state list. So different states have different laws regarding this. So this was about today's class. I hope I had improved from the last class till now. I was a little bit nervous. I don't know why I was nervous while recording this lecture. So I hope this will help you understand these. This would help you to understand these topics. And one more thing, this is most important, that these topics are very much important for your exams, regardless how I was able to explain it or not. But the information which I have given in these slides, these are very much important for you. If you are not able to understand what I'm explaining, but at least try to mute this video and write down these points. This would definitely help you in your exams if you would understand it and memorize it. Definitely questions would, most of the questions would come from the current affairs. It is how we channel these current affairs into our subjects. This is the most important thing for an aspirant. And these topics, these are already channeled by different magazines, and I am bringing it to you guys. So I hope you would like this initiative, and I hope you would start watching my videos and you would start sharing it with your friends. And I hope you will give good comments if you would ever watch this video. Thank you very much for clicking on my video. Till now, I can say only this thing. Thank you very much. And best of luck to your exam.